Welcome to Environmental Law course, dear learner and viewer. Today we are going to discuss about the legislative precept for the human right to environment in India. As you recall, in the last lecture, we have discussed the human right dimensions of environment protection in India, and then in this part, we'll be specifically dealing the legislative precept on the human right to environment. You may rightly recall that during the last lecture, we have tried to elaborate some aspect of the legislative precept in relation to what we can call is something known as 42nd Constitutional Amendment 1976, wherein we have examined the nature, content, and purview and scope of Article 51, 48A and 51AG, and we have tried to look at the very potentialities of these two articles in the 42nd Constitutional Amendment as to what is the goal post of these two articles which have been inserted by way of 42nd Constitutional Amendment in 1976, and we have tried to see that whether it is going to create a kind of a technocentric view, and we are of the view that it does not have any kind of a technocentric view. Rather, it tries to transgress from ecocentric to anthropocentric or transanthropocentric. When we appraise Article 48A of the Indian Constitution, which talks about protection and improvement of environment and safeguarding the forest and the wildlife of the country, then we see that this constitutional amendment casts a duty on the state to protect, and that duty is a mandatory duty to protect and improve. That is important, that the protection and improvement, and as well as to safeguard, protect, and improve the environment and safeguard the forest and wildlife of the country is definitely a kind of an ecocentric approach which has been permeated into Article 48A. But when we try to see, as generally we believe that Article 48A is except that it belongs to a state and it belongs to citizen, there is not much difference, but a careful examination of these two provisions and compare and contrast reach to the point that it has altogether different hue and colors and shades into the entire jurisprudential basis of environment protection vis-a-vis the human rights in India. How that we will see that every citizen shall be under a duty to protect and improve the environment. Here, the word natural has been mentioned, and the word natural is something happens to be that whether the biotic and abiotic entity both are encompassed. Once we are sure of the fact that the natural environment, the word natural is not appearing here in the context of Article 48A, but it is mentioned in the context of Article 51AG, then we can say that it is going to be have an not only anthropocentric but trans anthropocentric approach or jurisprudential basis of environmental law. And then we also try to see something beyond that is compassion to the living creature. So then we feel that the compassion, the benevolence, and kindness, as we discussed in the last lecture, are moral, ethical, religious duties which have been permeated into the legal discourse and legal arena as a part of the duty, and that serves as the jurisprudential basis of environmental law. And with a great degree of satisfaction and clarity, we can say that the 42nd Constitutional Amendment in general adopts ecocentric approach, and 42nd Constitutional Amendment 1976 through the mechanism of Article 51 AG adopts an anthropocentric and a transanthropocentric approach, and thus we see that can we go to the question of the human right to environment beyond Article 48A and 51AG, as most notably and vociferously argued, that has given a kind of a jurisprudential basis. Here we will try to see that beyond 42nd Constitutional Amendment, still we find something very salubrious in the Constitution of India, and here we will try to establish, as we establish here, the ecocentric and anthropocentric and transanthropocentric approach under the 42nd Constitutional Amendment by a comparative and contrasting study of Article 48A and 51AG. Similarly, in this slide, we'll be going to discuss that how the triangular relationship beyond Article 48A and 51AG have tried to create a kind of a jurisprudence, and that jurisprudence is starting from Article 47 or Article 48A. So what we can do, that we will see Article 47, Article 48 and Article 48A, and all these three articles give a triangular nexus of health, environment, and animal welfare. And then by saying that, then this environment protection is also going to be anthropocentric as and trans-anthropocentric approach. Why? Because here the animal life and animal welfare have also been given a paramount importance. So let us peruse what Article 47 is. That Article 47, as we have seen, that Article 47 was the only article which have been made a reference point and a moot point in by Justice V.R. Krishna Iyer and O. Chinnappa Reddy in Municipal Council Ratlam versus Vardichan. Though that decision was handed down in 1980, there was 42nd Constitutional Amendment already in the constitutional law. But if you look at the Municipal Council Lattam versus Verdichan, we do not find any kind of a reference of Article 48A. Rather, it tries to see the entire question of environment in Article 47, and Article 47 cast a duty on the state to raise the level of nutrition. And then it also talks about the standard of living, number 2. And then it also talks about improvement of public health, and how it is a kind of a gradual effort, that unless the level of the food, unless the level of nutrition is attained, how the standard of life is going to be determined, and unless the nutrition and the standard of life is missing, how the question of improving the public health can be a goal of the state. Therefore, it casts a mandatory duty by saying that a state shall regard the raising of level of nutrition and a standard of living by improvement of public health as a primary duty, as its primary duties. And in particular, it has two parts. One part serves the state shall regard raising of level of nutrition, standard of living, and improvement of public health. The another part, this is the first part. The second part says the state shall endeavor to bring prohibition of consumption, except for medicinal purposes, of intoxicating drink and drugs which are injurious to health. That aspect is well taken care of in a broad mandate of right to health in under the directive principle of state policy. Whereas if you peruse Article 48, then it talks about organization of agriculture and the animal husbandry. These two things are there. That's why we raise this question of the biotic and abiotic entities are primarily covered under Article 48A, that it tries to go beyond the standard of life, go beyond the public health, go beyond the nutrition, and these things are something anthropocentric. But when we talk of agriculture, when we talk of animal husbandry, then what we see that the state shall endeavor to organize agriculture and animal husbandry on modern and scientific line. This modern and scientific line is important, that it has not used the word sustainable development, but it tries to give emphasis when it talks about modern and scientific lines. Then we presume here that what has been said under Article 48A about the agriculture and animal husbandry. It is going to be sustainable, and then in particular it talks about preserving and improving the breeds, prohibiting slaughter, cow and calves, milch, and other drought cattle. That is something that is called the animal welfare. That animal welfare is also there. So we see as Article 47 of the Indian Constitution from level of nutrition, standard of living, public health, and then try to set aside the pernicious habits of intoxication in the way of the realization of right to health. On the other hand, Article 48A talks about organization of agriculture, animal husbandry on modern and scientific, but the word sustainable development was not used, sustainable agriculture was not used, or sustainability was not used in here, but we try to find and we try to mean it, and by saying that, we also see that this article also gave rise to the animal welfare. Thus, we see that the entire triangular nexus of life, health, livelihood, environment, integrating the animal health at the one place give rise to abiotic entities, and it at the same time it also promote trans anthropocentric and deep ecological approach. And then we can say that why it has been chosen to amend for any kind of amendment in relation to environment. It was not named as 47A, it was not said as 45, not 46. Then Article 48A means that it has a logical connection with Article 48A. So therefore, what the legislative precept of the human right to environment we are going to study is the fact that we should take Article 47, Article 48, and Article 48A. Clubbing Article 48 and 48A is important in the sense that this is very important from our point of view to track the human right legislative precept of human right to environment in India. With this, that with this we try to see that how it result into how it has been reacted into one of the most specific, moving from Constitution of India to Constitution of India to what you can say we are directly switching over to Environment Protection Act as one of the basic law on the environment. How that basic law on environment, that is Environment Protection Act, which has been passed in 1986 under Section 2A, tries to visualize, try to envision the whole question of environment, the whole question in environment, meaning thereby technocentric, meaning thereby ecocentric, meaning thereby anthropocentric or trans-anthropocentric approach, that biotic approach, abiotic approach, and then we try to see that what we have applied in the jurisprudential basis of the environmental law under 42nd Amendment, under Article 47, 48, and 48A, we are going to do the same exercise with our parent enactment, that is Environment Protection Act. And in this reference, the attention is drawn to see that how environment has been defined. That is most important. Number one, water. Number two, air. Number three, land. So environment includes water, air, and land. And then there are two conjunctions which has been used. One is the interrelationship, and that interrelationship which exists among and between. It means it talks about singular and the plural relationship between water, air, and land. And then, besides water, air, and land, it tries to have one human being. Number two, other living creature. Number 3, plant. Number 4, microorganism. Number 5, property. Then we find 3 plus 5 equal to 8 items, and this is the relationship of the environment which has been permeated under Article 2A. So, legislative precept of the of human right to environment in India can also be studied from the point of view of the Environment Protection Act, and we will try to see that the very definition of the environment, which is given under Section 2A of the Environmental Pollution Act, which have given a very elaborate and exotic enumeration of all environmental entities, then we can safely say it also emphasizes on the anthropocentric approach. It also emphasizes on the biotic approach. It also emphasizes on the abiotic approach. It also emphasizes anthropocentric approach. It also emphasizes on the ecocentric approach. So the jurisprudential basis of the environmental law is in India, right from the Constitution of India down to the one of the most vociferous elaboration of the environment, that is Environment Protection Act, which have been interpreted in a very broad manner, try to see not only the technocentric, but it try to see a kind of a judicial interpretation which is very cosmological in approach and which is very holistic in its approach, and that holistic approach must be understood in its penultimate analysis of what we can say is the legislative precept for the human right and environment in India, and that is to be further be carried forward in the legislative precept, and then we will try to see that how the constitutional goal of the human right to environment, how the Environment Protection Act's visualization and display of the biotic and abiotic and anthropocentric and transanthropocentric approach have been coupled with protection of Human Right Act of 1993, because we are going to discuss that what is the legislative precept of the human right to environment in India, and then we are going to now discuss beside the Constitution of India, beside the Environment Protection Act of 1986 as most parent act, an umbrella enactment on the issue of the environment protection in India, we are now going to see that constitution and the environmental law, how that can be close circuited to the human right law, and the basic law in this country in India happens to be the Protection of Human Right Act 1993, which was passed in the backdrop of Vienna Action, Vienna Declaration, and Program of Action on Human Right 1993, and India was very alert, very quick, and very responsive that what has been declared in the Vienna Declaration and Program of Action in 1993, then in the same year, India has come out with its first law on the subject of human right, and like we have the first law on the environment, that is the Environment Protection Act was came into being in 1986. Similarly, the first law having the word human right per se has been included in the Protection of Human Right Act 1993, and especially that the whole law deserves to be studied from the point of view of the human right, because India has played a very key role in fostering human right among the developing countries, and it has acceded to a large number of international agreement, treaties, convention, covenant, recommendations, and the protocols and declarations. And then, but we were feeling that as we don't have environment law per se, we were not having human right law per se, but in 1986 the Environment Protection Act filled that void, Similarly, the Protection of Human Rights Act 93 has also filled that gap, and the whole act remains to be studied in a very careful manner. But for to be very succinct and brief here, for our discussion on the legislative precept for the human right protection of environment in India, we are we are discussing section 12F that gives the National Human Rights Commission, which was established year 1995, that has power to study and recommend the TT implementation. Here, this power is very important, which vests with the national human right. And now the question is that is the power the NHRC has been empowered to study and recommend treaty implementation, meaning thereby that the National Human Rights Commission and Protection of Human Rights Act 1993 can go beyond the first generation of human right, can go beyond second generation of human right, can go beyond third generation of human right by a careful study, constant recommendation, and constant implementation to refurbish, reorient the human right regime in India. And that way, the section 12F makes a recommendation. Here, the National Human Rights Commission has a broad mandate, and nonetheless, in this broad mandate, we do find that the National Human Rights Commission have not lost its sight to look into the question of violation of human right in the arena of the environment, and how that in the arena of environment, although under section 12F, the National Human Rights Commission have not undertaken any kind of a study, have not taken any kind of the recommendation, and have not implemented any environmental treaties and convention for the protection of environmental right. But it is at the same time, it is not oblivious of the fact that what is its mandate, and then it tries to give some focus on the human right, how that is to be studied for the first time, that it talks about the project affected people, that India embarked upon the dam building industry, and while embarking on the dam building industry, the India in a massive way, right from the independence, then it tries to create and try to dam all major rivers in this country by the Land Acquisition Act of 1894, and then it declaring that area for the national purposes and for the national development, and thus it resulted into massive displacement of the people. Now the question is that the person and the people who are displaced in the name of development, are they going to be settled and resettled and rehabilitated in a very amicable and peaceful way? That question was looming large in the entire spectrum of the term of reference, the National Human Rights Commission, and the question of development induced displacement was a very critical issue from the standpoint of the realization of human right to environment in India. And it says that more than 33 to 50 million people have been displaced in this country from their hinterland, from their motherland, from their prime land, and they are considered to be the refugee, internally displaced person, refugee in their own homeland. And that state of refuge, that state of the asylum at the different places, having exceeding a kind of a population of some nation like Australia, and then the historical refugee crisis which India is having for by the internal displacement of the people's affected project affected people, was a kind of a series of trials and tribulations which they have faced. And though there has been regular promises and assurances from the funding agency, most notably the World Bank, in regard to see their resettlement and rehabilitation packages to see and work on the ground, but the population of the dam austes remains a major concern in the NHRC's zeal to implement the environmental right and implementation of the human right. And that's why we see that the NHRC, National Human Rights Commission, has rightly intervened in the Bargi Dame Austis case, and it symbolizes the plight of the displaced people. And then by the activism of the National Alliance for the People's Movement, sought the intervention of the National Human Rights Commission, and after having an official violence and peaceful protest, then NHRC have created a kind of an inquiry and recommended measure to improve the conditions of the Barge Dam Austes, and then it also directed the state government to look at what this directive means and how they are to be suitably rehabilitated in order to fulfill the constitutional conscience of right to life, personal liberty, human right, and especially right to environment or the human right to environment, by giving recognition to the international obligation, especially the ILO Convention 169, which talks about the people who are displaced out of the developmental project and are to be suitably rehabilitated. Then we also see that on some very critical issue of right to potable water and right to sweet water, right to safe drinking water, that India has 226 million people affected and has been denied the safe drinking water and potable water and sweet water. Then NHRC has drawn its attention and, and directed the government to provide the basic necessity and the basic essentials of right to water. And then the National Human Rights Commission also addressed the question of the arsenic pollution and groundwater contamination in two states, the one in the West Bengal and Andhra Pradesh. And in relation to the Bengal arsenic pollution, NHRC has affirmed that this kind of a water pollution affect right to life and personal liberty under Article 21. Justice Ranganath Mishra, the chairperson of NHRC, as then he was, ensured that a healthy environment is an integral part and fundamental human right. And this is something very salubrious to note, that so far we have discussed and reflected on the case law, but the very institutional mechanism which the India has, meaning thereby the institutional mechanism, because after studying the legislative precept of the protection of human right to environment in India, we are switching over to the institutional mechanism, and then we confine our study only to the National Human Rights Protection of Human Rights Act and National Human Rights Commission's activism and recommendation, then we find a large number of cases wherein the NHRC have intervened. And then in matters of the Bengal arsenic pollution, and the observation is very pithy and substantive, that it ensures a healthy environment, uh, and healthy environment is integral part of the right to life and fundamental human right. And then it also addressed major questions of the lapses of the environment induced health problems in India. And then we also see in the on the other sphere, the NHRC has highlighted the widespread iodine deficiencies impacting the mental health of the people and the future generations. And then the question of, beside the question of environment, the right to human right to health was also being combined, as it has been combined in case of right to safe drinking water. Then it has been also combined that any kind of an iron and iodine deficiencies among the generations of the people will put the entire population in jeopardy, and therefore this also breaches right to life and personal liberty. And then the question of health and environment both were clubbed together by the National Human Rights Commission. Then coming heavily on the question of right to dignity, vis-a-vis right to sanitation. The Human Rights Commission have identified the problems of manual scavenging which has been practiced despite the fact that we have a Manual Scavenging Act 1993, and even after the implementation of that law, the pernicious practice of the manual scavenging by the manual scavenger is something, a kind of a blot, something a kind of a shame, and then it wanted to prohibit the practice and prompting its enforcement in several states in 1997 by the intervention of the National Human Rights Commission. This case, beside right to health, right to environment, talks about right to sanitation, as well as it also talks about right to human dignity of the manual scavengers. And then it in 200 2500 tons, that the problem of enforcement of the Manual Scavenger Act was also redressed and given a kind of an attention for immediate implementation, and then removal and abolition of the practice of the manual scavenging. The National Human Rights Commission was also very sensitive to many other political issues, environmental issues, and giving way to a kind of an environmental justice. And that question of environmental justice have also been addressed by the National Human Rights Commission. Having said so, what in this lecture, dear learner and viewer, we try to reflect upon and we try to impress upon is the fact, as in the last lecture, we have tried to draw a synoptic outline of human right to environment in India. Here we wanted to touch upon number one law is the law relating to Constitution of India, and we in the constitutional study we have made two kinds of discourses and perspective. The one discourse to look at the legislative precept of the human right to environment in India is through the mechanism of the 42nd constitutional amendment, and by reading into Article 48A and 51AG to establish that what are the environmental foundation, what are the moral foundation, what are the goal posts of this legislative precept, and then we try to be convinced ourselves that these two articles essentially lead to ecocentric and anthropocentric and trans-anthropocentric approach, giving more space to both the biotic and abiotic. This is something very novel in the sense that human right being excessively human in nature, nonetheless, it has encompassed as a parent battery to give effect to all inanimate object. Then the other constitutional part, we have taken note of Article 47 and Article 48A, and we wanted to make a kind of a triangle of Article 47, 48, 48A to see the question of environment, question of health, question of animal welfare, how these things are addressed. Then we directly hit hard to Environment Protection Act 1986, looking at Section 2A and its brilliant exposition of land, water, air, and its interrelationship with human being, plant, other living creature, plants and microorganism, and property. And then we try to move the Protection of Human Rights Act 1993, especially Section 212F in the context of Vienna Declaration and Program of Action 1993. And then we have tracked that NHRC's initiative for promotion of human right to environment in India in matters of project affected people, in matters of bargain dam austies, in matters of the drinking water shortages of the people, in matters of Bengal arsenic pollution, in matters of the abolition of manual scavenging. Then we try to see that the legislative precept for human right to environment in India is one of the most emerging area, and that needs a kind of a very careful understanding. And alongside we study the statutory law on the environment, or the environmental law per se. We should be equally be very attentive to the constitutional goal and as well as the human right goal through its legislative precepts in India to promote human right to environment in India. With this, I thank and I wish you a happy learning.